The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. We are here this afternoon for the submission of 4 cases. The case of Iowa Supreme Court Attorney Disciplinary Board versus John Fisher is hereby submitted without oral argument. The case of State of Iowa versus Justice Mathis is hereby submitted without oral argument. Our first oral argument for the afternoon is Rosa Chavez versus MS Technology. Parties ready? Ms. Tucker, you may begin.
May it please the court, counsel. We're here today to resolve an ambiguity that was created by the 2017 legislative changes to the Iowa workers' compensation statutes. Primarily, the issue before you today to determine is what is a shoulder. In 2017, the legislator amended the statutes to include shoulder as a scheduled member body part under Iowa Code Section 8534. Before the amendments, we knew that the shoulder was identified by this court as the joint of the shoulder as the glenohumeral joint. Specifically, injury to a joint such as a shoulder is treated as an injury to the body as a whole. That was well known for many, many years, and we didn't have any reason to differentiate the different body parts involved. We urge this court today to adopt a definition of the term shoulder in a simple and straightforward way. It was previously defined as the glenohumeral joint. That definition can be adopted as the scheduled member body part that was added to the list. And we can limit shoulder injuries to the glenohumeral joint.
Presume that an amendment is made for a reason. And so if that was the definition before, what was accomplished by the amendment?
It did no definition. It did not include what body parts would come down within the definition of the shoulder. So without providing any instruction or how it would be applied, we have to look to the statutory definitions we already have. And that prior statutory definition was the shoulder was a joint. It separated the arm from the body as a whole. Now, with this amendment, it did change the law in that we have a new subsection of injuries that fall within the joint. And some injuries will fall.
Sure, if it's to that joint. But what as a matter of statutory interpretation, when we have shoulder joint in section 85.342M, and then after the amendment, just the term shoulder, doesn't that show the legislature meant something broader when they say shoulder instead of shoulder joint?
That original draft that I think you're referencing was the study bill that the commissioner cited to in his interpretation of this. And the law is clear that we shouldn't look to those study bills because they were drafted by a handful of legislators and not the whole body. But I think it's evidence that they wanted the shoulder joint to be a scheduled member body part because they first listed it included in the arm schedule, including the shoulder joint. And then the amendments that they later made were all more beneficial to the injured worker. So they took out the shoulder joint and made it its own category out of a greater number of weeks. So
How do we evaluate shoulder impairment without evaluating the rotator cuff, which allows your shoulder to function properly?
Guides allow for the doctors to evaluate patients, and they've been adopted by the commission as the authority to use to determine what impairment would be to the shoulder joint itself. For a labral tear, for example, would be contained within the joint itself, and the guides allow the doctors the testing and procedures range of motion that they can do to identify what the medical evidence supports an injury limited to the joint. Our interpretation creates a bright line rule.
Work and practice a little bit. So shoulder, however defined, if it's a scheduled member injury, you'd have an impairment rating, and then you could determine compensation based off 400 weeks. Potentially total compensation would be 400 weeks, and then the impairment rating, the worker would get some percentage of that. Is that correct?
That's the way the functional loss operates.
An injury near the shoulder area, but wasn't a joint in your reading of this, then it would be a body as a whole injury. Is that right? And then the employee would be entitled to 500 weeks compensation based on an industrial disability rating. Is that correct? Okay. So in each case, even if the injury were the same for the worker, if it was a whole body injury, the disability rating would always have to be litigated because that would depend on the facts and circumstances of that worker's field, education, training, job availability, et cetera, right?
In some circumstances, not always, but you're right. If it's a body as a whole injury, we take into consideration not only the functional loss, but the age or the worker's age and education and work experience. So
This is kind of an odd case because it seems like you're saying a liberal construction in favor of the worker, but rather than seeking certainty of coverage as a scheduled member injury, you want to narrow that and then make it a body as a whole injury subject to litigation in almost every case regarding the extent of the industrial disability. That actually seems to be contrary to the worker's interest. Am I wrong in thinking that?
you are wrong in thinking that, only because if we limit it to the scheduled member body part, the functional loss is it. It's an arbitrary calculation. We don't get to consider anything worse else. So if that worker is unemployed and unemployable, it doesn't matter. They get the functional loss to their body. If it's a body as a whole injury, we get to look at their true lost earning capacity and their ability to engage in gainful employment.
So based on the same impairment rating, that would inform the scheduled member injury, right? You have the impairment rating and then also the additional industrial disability determination, right?
AMA guides kind of control this area, but the doctors assign a functional impairment loss, and that gets converted to a body as a whole loss. So we look at the rating for the body as a whole, and then all of the other factors to determine what their industrial disability is, versus a functional loss that's just arbitrary based on the schedule, and we don't get to consider anything else. But I think another way that this creates a balance here is that the legislature did provide for still an analysis of the functional loss only when that worker is back to work earning the same or greater wages. What that means, it's still yet to be determined. But there are many times where there is a body as a whole injury, and we can develop what we believe the industrial loss will be, because you see kind of the similarities with other cases. So it doesn't mean they all have to be litigated, and we always have to have the commissioner determine what that industrial loss is.
You know, if it's a scheduled member injury, you probably have less litigation, but the total compensation would be less. And if it's a body as a whole, at least as you're looking at it and the claimant's looking at it, there'd potentially be more litigation on the disability rating, but the upside would be potentially 100 additional weeks of disability benefits, 400 to 500, right?
The shoulder as scheduled, can't foresee any way you'd lose 100% of the shoulder, where you'd ever have a 400-week loss, because it's not like an arm that can be amputated. You can't lose it. We don't know where it starts and we don't know where it stops. It's ambiguous. And that's really what it comes down to, is we have an ambiguous term, and how has it been interpreted in the workers' compensation law for decades in favor of the injured worker. And assessing the true value of their loss is the only way to compensate them for the industrial disability that they have versus the functional loss to that body part. And it actually would create less litigation, because the way that the commissioners interpreted the term now is very broad. He says anything that's important to or entwined with the shoulder. And we will be arguing for a long time about every little body part in the quadrant of the body and its importance to the shoulder joint. That is a very ambiguous way of interpreting it. Our definition provides a bright line. We say injuries that are within the joint, and looking at the diagram I've provided on the left side, that's the labrum, the glenoid area. If there's an injury there, it would fall within the scheduled member body parts. But keeping with the humanitarian purpose of the legislation, the workers' compensation statutes, anything that's proximal or body side and attaches to the body, like these massive rotator cuff tendons that Ms. Chavez tore in this case, it would be a body as a whole injury to be evaluated industrially in her ability to engage in gainful employment based on a lot of different factors. And in that way, that is the most beneficial to her versus getting the functional loss and not being able to potentially work in any capacity, and that's it. She has no other remedy under the law for her losses. So, we have to look at the words the legislature actually used. They used the word shoulder. They didn't use
A shoulder joint. This statute has to mean something. Am I correct that what you're asking us to do is to define shoulder how it used to be before the 17 legislation? Where you have the glenoid and the labrum, you're going to learn my level of medical words, how to pronounce them. But where the argument was if it's proximal, it's with the body part, otherwise it's with the arm. Aren't you asking us to rely on our cases, our prior cases? So why would why help me understand how that's an accurate representation of a change in a statute? Isn't it reasonable to assume that it now means something different?
Our interpretation would create a change in the statute. It would create three parts: the arm, the shoulder, and the body as a whole. The legislature didn't intend to change the proximity or the proximal cases that we've developed over years, that anything, when we're evaluating scheduled members, the proximal, closer to the body part, scheduled member is the one we apply because it's more beneficial to the injured worker. An example is the wrist. The wrist is a joint. It's not listed on the schedule, but it's been interpreted to be part of the arm. Even though it may be important to the function of the hand, it's part of the arm because it's proximal, closer to the body. So it becomes, they've adopted the arm as the schedule in which it applies. The shoulder's the same way. The joint has its own scheduled number of weeks now. But anything proximal or closer to the body is body as a whole because it impairs the body. And it's not enumerated in the statute. And we're talking about rotator cuff tendons here that my client tore, a massive rotator cuff. That's not enumerated in the scheduled members. Anything not specifically enumerated, we apply unscheduled, body as a whole, and it's evaluated on an industrial disability analysis. And the fact is we have two interpretations here. The deputy commissioner interpreted it this way, that the schedule is limited to the joint, and in this case it was a body as a whole injury, and the commissioner has interpreted it differently. And it's up to this court to determine which interpretation we apply. And if we keep with the humanitarian purpose of the workers' compensation statutes, that interpretation should be most beneficial to the injured worker. That's something the legislature did not change. They did not change the intent of the statutes. They did not state that we want this to be viewed most beneficial to the employer. It's still the same principles that we have and have applied.
Give to your client's medical records, which have the word shoulder injury all over the place.
The fact is that medical terms are not always compatible with the statutory definitions, and we've learned that in workers' compensation. The commissioner in this court has had to interpret what specific terms mean, like the wrist, as the example I gave earlier, and we didn't have any reason to differentiate between parts of the body that are body as a whole and parts of the body that might be within the definition of shoulder. So it's ordinarily called the shoulder for a long time by both medical professionals and
If there's one part of my shoulder, and I think I know personally with the rotator cuff where that is, if that's not working right, I've got problems with my shoulder, don't I?
Maybe generally speaking, but the legal definition and the interpretation of that term is yet to be decided and how it would apply. Because if we look at the anatomy and the parts that you would consider a part of your shoulder, it attaches to the body as a whole. And the law says if it affects the body as a whole, that's the situs, the anatomical situs of the disability.
Being calculated by the experts, the medical experts, don't they look at range of motion of this, that? They're looking at all the moving parts of that area, not just the narrow issue you're asking us to look at. How do you even do an impairment evaluation if you don't consider all the other parts that go with it?
They do an evaluation based on the range of motion, and the guides, the AMA guides to the evaluation of permanent impairment give them the different ways to do that. But they look at the medical records too. They look at the procedures that were done, the surgeries that were performed, what the imaging studies show, and if they evaluated an injury to certain parts that we know are located in the joint, that's easy to obtain. That's easy to see from the outset. Because it is the anatomical situs of the injury that controls. We need to know exactly where the injury happens on the body, and if it affects the body as a whole or a non-scheduled member, its body as a whole.
You'll get a chance to come back again in a minute.
Yeah, my time is up. Thank you very much.
Utsinger?
May it please the court, counsel. Good afternoon. First, I'd like to touch on liberal construction. And there is no disagreement here that Workers' Compensation Act is generally liberally construed in favor of the employee. However, this own court has said it is not without limits. In the Grundmeyer case, there is one very important limitation on the rule of construction. We liberally construe the statute insofar as the statutory requirements permit. Here we are dealing with the new scheduled member statute. We're looking at the statute as a whole, giving ordinary and plain meanings and not resulting in absurd results. And in fact, liberal construction was met here. This is an accepted injury. The compensability standard remains. This arose out of, in the course of employment, her medical benefits were paid, her time off of work was paid, and she also received permanency. Just the crux of this case involves how much permanency. In terms of the anatomy, there's also no dispute in this case. This involved 3 out of the 4 muscles of the rotator cuff and the labrum, though clearly the most disputed issue here is the rotator cuff. But I would like to talk about 8534 in a bit more detail, because just as with legislative intent, what is included and what is omitted are equally important. And Your Honor, your justices have hinted at paragraph M, or subsection M. Joint is there in defining the arm, and joint is also there in defining the leg. So if the arm goes from the shoulder joint to the elbow joint, however, the omission of joint is noticeable in subsection N. They use the broader term shoulder. Again, there's agreement. There's a presumption that the legislature knew what the law was, but there's an equal presumption that if there's an amendment, they meant to change it.
Opposing counsel has suggested a bright line definition. What is your proposed definition of shoulder?
Include the rotator cuff, as that is the essential function to make the joint move. The joint is static without the rotator cuff. The legislature used the broader term shoulder, and in fact, to do the range of motion exercises per claimant's own expert, Dr. Banzel, abduction, adduction, and that's how is accomplished solely through the rotator cuff.
Definition like that, do we have to overrule our past Iowa case law regarding proximal point of the joint and all that business?
Shoulder, because the shoulder is now on the schedule. The proximal distal would still remain for the hip, wrist, ankle, though the legislature has the power, this is a statutory animal, to even place those on the schedule. But they put the shoulder on the schedule. That's where I would disagree that the prior case law defined the shoulder only as a joint. It was just necessary to create a dividing line between what is the arm and what is the body as a whole. And in fact, if those cases discussed general shoulders, and if those cases were decided today, believe they would be put on the schedule, the Alm case alone had mentioned that nor is the shoulder a schedule in this code section, so they did not have the option. So I'm not asking to completely disregard the proximal distal argument, as it still applies to other body parts. But now that we have the shoulder on the schedule, it would no longer apply. And using the broader term shoulder is enough to encompass the rotator cuff, which is essential to the movement of that body part in general.
Of the commissioner's interpretation of the statute.
In placing the rotator cuff. I mean, there's been discussions between the Dane case and our case as to whether this term is broad or ambiguous. In our case, it's been ambiguous. I would classify the term just as broad, and I would request that we affirm the commissioner's level and also the district court in defining the shoulder as the rotator cuff. I know that the statute, that's not vested within the commission to interpret. That's why we're here today. But they're the front line of this. They see the medical evidence. Again, we're looking at a common ordinary meaning. Right shoulder is everywhere in this case, including by the expert, every expert, Dr. Ash, Dr. Peterson, Dr. Banzel. Even Dr. Banzel noted that the focus was on the right shoulder and gave diagnoses and impairments. All of the physicians even used similar tables within the guides to do those range of motion exercises and provide functional impairment.
Contradict the legislature's interest in encouraging employers to keep injured workers?
No, because at the end of the day, all accepted injuries are still going to be part of the schedule. Compensability doesn't change. Everybody still wants a safe work environment. There's still exposure on injuries. There's also review reopening rights. So there has to be some balance as to body as a whole and scheduled member. And again, this is a legislative creation. They have the right to add, amend, change causes of action, add new causes of action, and that the broader interpretation would go with the statute as it currently stands.
I asked earlier, but I will ask her when she comes back. What about the claim by Ms. Chavez that she has actually two scheduled injuries?
Agree for that. That's a substantial evidence standard, which is a little bit different than what we're dealing with in regards to the interpretation of the shoulder. That was found to not have met her burden of proof in that her own expert didn't provide a separate impairment rating for that individual injury. The biceps injury actually occurred at the attachment of the shoulder. It was reviewed as a singular incident and given an impairment rating as a singular incident that would include claimant's own expert. So based on the substantial evidence alone, all of the experts in this case have treated this as a singular. Now there could be situations where you would have an upper extremity and shoulder, possibly at the arm, possibly down at the wrist, but the facts of this case in particular don't support that. Yes.
This definition of shoulder as a scheduled member did not include the rotator cuff. How often would this particular item come up? I mean, how often does that happen that you have a shoulder injury that's not a rotator cuff?
I think the additional briefs submitted in this case by the other interested entities show that rotator cuffs are pretty common. And in fact, if we kept the limited interpretation by the claimant, I believe it would make the statute fairly meaningless. Scheduled member, or the rotator cuff currently is highly litigated because of the larger functional impairment plus all of these additional factors, your age, education and all that, that's generally dispute. Whereas if we put a bright line functional impairment on the schedule, it's going to give employers easier to know what they pay. These employers get their permanency quicker, and that should ultimately, though there's going to be some increased litigation now just defining it, will ultimately lead to less litigation. And then we'll fall into things like your leg and your arm. Where's that set standard as to what to pay on the permanency?
As to opposing counsel's suggestion that it would be very rare to have a 400-week, 100% of a shoulder injury.
There could be certain, it would be unfortunately probably a catastrophic thing. Typically your shoulder replacements are in the 24%. But that would be the same, that would be also under the guides. Would be relying on the physicians and the AMA guides to evaluate that. That would be beyond my expertise as to whether you could, but I would agree that would be semi-rare. There's also one additional issue I'd like to discuss as an alternative argument. That was the industrial disability argument in terms of the functional impairment. Again, that comes into play here because regardless, if you return, you have the shoulder as a scheduled member, that's functional impairment. Ms. Chavez has provided the alternative argument as to an industrial disability at same or greater wages. My argument is that's a substantial evidence issue. This should always remain as a shoulder, rotator cuff, scheduled member injury. But if not, she returned to work at same or greater wages and should be still limited to functional impairment. Interestingly, that would result in less functional impairment than she did receive per the commission appeal decision. But overall, it is the employer insurance carrier's position in this case that the legislature clearly changed the law by adding the shoulder to the scheduled member. They used the broader term shoulder instead of using joint where they had in other spots on this schedule, including in its own definition of the arm. The rotator cuff is essential in the movement, is essential, and it really is the main structure that will provide the movements necessary under the AMA guides. It's in line with legislative intent. This is within the legislature to control as a statutory construct. It's within the liberal interpretation of the statute. For all of these reasons, I would ask the court to affirm the prior decisions in this matter, particularly the commission and judicial review decisions. And if there are any other questions, I would always refer to my brief as well.
Answering that question that I wished I had asked you earlier about the two injuries.
Absolutely. So again, this brings us back to the principle we have in workers' compensation that if it's not specifically enumerated on the schedule, it's unscheduled. And there's the subsection in 8534 that talks about 2 arms, 2 legs. If you have bilateral injuries to both arms, you get 500 weeks. Okay, it's out of 500 weeks. It didn't put shoulder in there. Shoulder was not added into that subsection for some unknown reason. So if you have an arm and a shoulder and they're permanently injured, that should be a body as a whole injury, the same way that 3 scheduled members has been analyzed, because it isn't enumerated on the schedule. So if you have 2 arms and a leg, you would be looking at a body as a whole or industrial claim, because the statute only talks about 1 arm or 2 arms, but not 3 scheduled body parts. So that's our argument on that. She had a permanent disability to both her shoulder and her arm, so she falls in this catch-all provision of nothing.
No separate impairment proof.
And the doctor, Banzel, our expert doctor, gave a permanent impairment rating based on the arm, because the AMA guides allow the doctor to, the upper extremity is how the arm and the shoulder are both evaluated under the guides based on the loss of range of motion. So we submit that the permanency assigned relates to both the shoulder and the arm. So that way that it encompasses the catch-all provision. But it's not our primary issue, it's an alternative issue. The bigger thing here, I think, is we can't give this term an ordinary and plain meaning because the statute did not define it. The legislature did not provide any insight on what it would be, what it would mean. We have a definition in the law, and it's ambiguous.
The joint question, and I think you've been asked it before, but it troubles me. The legislature knows how to use that term in connection with other locations of the body. They did not use it here. Doesn't that at least give the inference of a legislative choice?
I don't think so, because they knew how it was statutorily defined or how it was defined by the courts in the past. But it cuts both ways. They didn't use shoulder structure or shoulder girdle, which is now how the lower court is trying to interpret this to include everything that has something to do with the shoulder, when the definition was very clear. It is a joint. It's the first joint to show up on the schedule. So they should have specified exactly where it starts and where it stops. And without that specificity, it is ambiguous, and we must interpret it in favor of the injured worker. The only way to do that here is to find that it is the injury in this particular case, at least, is a body as a whole injury, and it impairs her body and not
legislature added shoulder, and if they did not intend to include the rotator cuff, what work does it do to have a schedule for the shoulder joint the way you want to define it? Does that cover very many injuries?
I can't give you the numbers on how many would fall within the shoulder, but they still exist. I mean, there are significant injuries to just the shoulder joint itself that come up over and over. The rotator cuff injuries are probably the greater number and more debilitating and career-ending versus the joint injuries, which may not be as significant. And with that, we do ask this court to find that the scheduled member does not apply in this case. Ms. Chavez suffered a body as a whole injury and reversed for the commissioner's interpretation of industrial disability. Thank you.
The case of Chavez versus MS Technology is hereby submitted. We'll just take a few minutes here for the next case to get ready.